Hello everyone, this is Dr. Sandeep Sektu, presently working as Assistant Professor at Himachal Pradesh University Institute of Legal Studies at Shimla. Today I am going to deliver a lecture on Article 12 of the Constitution of India. This Article 12 defines the term state for the purpose of fundamental rights. These fundamental rights are contained in Part 3 of the Constitution. And this part third contains the provisions right from Article 12 to Article 35. And the very first provision is state, which is contained in the Article 12 of the Constitution of India. An obvious question which arises over here is why this term has been defined at the very beginning of the fundamental rights. The answer is very simple. All these fundamental rights are available against the state. So far as normal persons are concerned, if a normal person violates the fundamental right of any person, that any person can approach the authorities. He can lodge the FIR. He can go to the police that such and such fundamental right of mine has been violated. But in case the police officer himself violates your fundamental right, what will you do? In that case, these fundamental rights which are available to you, you can approach directly either the Supreme Court or the High Court. This police basically is state. Not only the police is included within the meaning of state, all the authorities are included within the meaning of state. And this Article 12 defines the term state. In case your fundamental right has been violated, you can approach the High Court or you can approach the Supreme Court. If you will approach the High Court, then you will have to file a writ petition under Article 226. If you will go to the Supreme Court, then there you can file the writ petition under Article 32. Whatsoever the case may be, in all these cases, these High Court or the Supreme Court, they can issue writs. And you must be knowing there are 5 types of writs: habeas corpus, mandamus, prohibition, certiorari, quo warranto. That depends upon the nature of the case, what writ is to be issued. Now, the very first thing, Article 12, which defines the term state, against whom the fundamental rights are available. So let us see what this Article 12 exactly is. Article 12 says that this term state shall include government and parliament of India, government and legislature of each of the state, and all local or other authorities within the territory of India or under the control of government of India. All these authorities I discussed, they all are state. First one, it said government and parliament of India is state. Then government and legislature of each of the state, this is also state. Beside this, coming to the lower level, all local or other authorities which are within the territory of India or they are under the control of government of India, they are also state. If any order or any law has been made by any of these authorities and that law or order takes away your fundamental right, then you can approach, as I said earlier, to the High Court or the Supreme Court of India. First of all, let me tell you the very first judgment on this point. Masthan Sahib versus Chief Commissioner. AIR 1963, Supreme Court 533. In this case, the Supreme Court simply said that this term state includes 3 entities. Firstly, government and parliament. Secondly, government and state legislature. And lastly, local or other authorities. And it further said these local or other authorities may be within the territory of India or they may be under the control of government of India. meaning thereby under the control of government of India. They are not within the territory of India but still under the control of the government of India, just like embassies. If any embassy which is situated outside our country, they issue any order, they make any law, and that law or order takes away our fundamental rights, still we can file a writ petition against them here in India under Article 32 or 226. That depends upon our sweet will. So let us discuss the ingredients first of all. What are these states against whom we have the fundamental right? First one is a government. Everyone knows government. But what exactly is the meaning of this government? Who is government? Can you see this government? If you are willing to file a case against the government, whom the notices will be served? Let me tell you first of all how the government works. Government basically works through departments. Entire work of the government has been divided under the departments like health department, education department, any other department. If the order has been issued under the education department, then you can sue the secretary education, right? Writ can be filed against him, right? So therefore, so far as writ is concerned, it is to be filed against the department itself, and this department basically belongs to government. And if any order is issued by department of government or any institute which is under the control of department of government, then also you can file a writ petition. I'll give you a very simple example. Department of government, let us take the example of health department. First of all, suppose health department issued some orders and those orders are against our fundamental right, we can file a writ petition. Secondly, if there is any institute which is working under the health department, for example, in Himachal at Shimla, there is Indira Gandhi Medical College, IGMC, or at national level, you can see there at Chandigarh, there is PGI. Right? This IGMC or PGI, they issued an order. What is the order? That on Sunday, emergency services will be provided only to the class 1 officers. This is the order. If it is a Sunday, then if class 1 officer is willing to seek some medical aid, it will be given to him. But same will not be provided to any other person. It violates Article 14 of the Constitution of India, right to equality. Right? So therefore, this order can also be challenged under the writ petition. It is not only the department of government, but the institute which falls within the definition of, within the control of department of government. If they issue any order which takes away our fundamental right, we can always file a writ petition. Right? Now, second thing, parliament or legislature. Let us discuss these two terms, parliament and legislature. Legislature of each of these states. Parliament is at the central level. Generally, we say, a common man, if we ask a common man, what is this parliament? Everyone will say, Lok Sabha and Rajya Sabha are the parts of the parliament. No. As a matter of fact, there are three necessary components of parliament. Lok Sabha, Rajya Sabha, and the president as well. President is an integral part of parliament. Let's come to these states. And in states, in majority of states, we have one house and the governor. So this is legislature. And in a few states, we have two houses. If we have two houses, then these two houses plus the governor is legislature. Right? So therefore, in state legislature, we have two type of systems. In some of the states, we have only one house. Right? Legislative assembly. And if we have only one house, then legislature includes legislative assembly as well as the governor. But in some states where we have two houses, legislative assembly, legislative council, then this term legislature of the state will include legislative assembly, legislative council, and the governor. Right? Now, if this state legislature or the parliament, they make any law, and that law takes away our fundamental right, then that law can be challenged. We have a right to challenge that law. Where? Either in the High Court or in the Supreme Court. These are the two courts only, right? Uh, if we go to the Supreme Court, I already have told you we'll have to go under Article 32, and if we go to the High Court, then 226 is the provision. Let's move further. Then the third ingredient of this term state is local authority. Before defining this term local authority, first of all, let us discuss the term authority. What is authority? As per the Webster's dictionary, authority means a person or a body exercising power to command. If any authority or a person is having power to command, then we call that person or the body is authority. Since we are talking about the Article 12 of the Constitution, for the purpose of Article 12, this authority means any person or body having power to make and enforce laws, orders, rules, regulations, bylaws, notifications, etc. If there is any authority, it is local authority, and they have certain powers not only to make the laws, rules, regulations, but to enforce the laws, rules, and regulations. Let us talk about this local authority now. Now, so far as this term local authority is concerned, let me tell you, bachalo, this local authority has not been defined in the Constitution of India. And in the Constitution, there is a provision. It is Article 367. And this Article 367 says, if any word or term is not defined in the Constitution, then the General Clauses Act 1897 can be seen. That means General Clauses Act can be of great help if a term or a word has not been defined in the Constitution. And let me tell you, the Section 3, subsection 31 defines the term of this General Clauses Act 1897, defines the term local authority. It says local authority shall mean a municipal committee, district board, panchayat, improvement trust, and mining settlement board. This is the definition given by this Section 3, subsection 31. Although it doesn't look like a definition, some points are given. Okay, this is local authority, this is local authority, or that is local authority. These are simply examples of the local authority. Supreme Court gave a very fine definition of this local authority, wherein it gave the characteristics of the local authority. So let us discuss that case. It is Union of India versus R.C. Jain. Union of India versus R.C. Jain. AIR 1981, Supreme Court 951 is the page number, 951. And in this case, the Supreme Court said that there are as many as 6 characteristics of local authorities. 6 characteristics. All of them should be there. If all these 6 characteristics are there, then we say the authority is local authority. And let me tell you what are these 6 authorities. But you shall keep in mind one thing. Like we are discussing what? We are discussing local authority, which is at local level, small. Like the definition was given, the examples were given. Panchayat, municipal committees, and municipal corporation. Keep panchayats or municipal corporation in your mind, and then see whether these things are there or not. First characteristics. First one is the authority must have separate legal existence. Like panchayat, they have separate legal existence. Municipal committee, it has separate legal existence. Then we can say yes, this is local authority, separate. Because the government, they are autonomous bodies. Government has no control over them. They are separate and they have legal existence. They are not illegal. Second ingredient. It must function in a definite area. You must be knowing in your panchayats, the area is limited. So therefore, there is a definite area. Even in municipal committees, municipal corporation, these committees or corporations, they are divided into wards. Ward number 1, ward number 2, ward number 3. And they have defined area. Right? Third ingredient, third characteristic. Election is most important. This authority must be elected by the habitants of the area. This is necessary. And you know, panchayat pradhans, they are elected by the locals. Parshad जिन्हें आप कहते हैं, right? Councillors, they are elected by the local inhabitants. Then comes the next point, autonomy. This autonomy is also important. Autonomy बोले तो there shall be no control of any other authority on this authority. And MC, panchayats, they are autonomous bodies. They have nothing to do with the state government or the central government. They are independent. They are autonomous bodies. Like the universities, government universities, they are also autonomous. Right? Then, point number 5. Power must be entrusted by statute. This is also important. Like Panchayati Raj Act. It creates what? It creates Panchayati Raj system. Municipal committees, they are also constituted under the act. So therefore, these authorities should have been created by some law. And the last ingredient, so last characteristic, 6th one, it must have a power to raise funds. For example, you must be knowing municipal tax. Municipalities, they can impose taxes on you. We are paying the property tax. If any authority is having all these 6 ingredients, then we can say that that particular authority is a local authority. Let's move further. Other authorities. Now, so far as other authorities are concerned, this term other authority has not been defined in the constitution, and moreover it has also not been defined in any other statute, right? But still, we have plenty of judgments of High Court as well as Supreme Court which talks about other authorities. Let me tell you in a few words. Initially, the local authority, the definition of local authority was very narrow. With the passage of time, the area, the field of this local authority has been expanded by the Supreme Court. We will discuss. Let us begin with the first judgment on this term, other authority. The very first judgment is University of Madras versus Shantabai. AIR 1954 it is a Madras High Court judgment. AIR 1954 Madras 67 is the page number. In this case, the Madras High Court applied the principle of adjustim generis, EJUSDEM, adjustim generis, GENERIS. It means of same nature. In this case, the High Court said, if there is any authority which look like the government or parliament, government or state legislature, then that authority is other authority. Which is similar, which look likes the government. Then, meaning there is some authority. It is doing governmental functions or it is doing sovereign functions. But it is neither it is government or parliament, government or state legislature. No, but it look like the government or parliament or government or state legislature. Then this authority will be other authority. This was a very narrow definition. And in this case, it was held that the Madras University is not state. The Madras University does not fall within the definition of state, unfortunately. But let us move further. Then the important judgment on this point, Ujjambai versus State of UP. AIR 1962, Supreme Court 1621. 1621. In this case, Supreme Court said, the definition given by the High Court, Madras High Court, is narrow. It is not only the adjustim generis principle which is applicable for the purpose of other authorities. Some other authorities which may not look like government, they can still be the other authorities. And here, although the principle has not been given, but it was simply said that the sales tax authority is an authority within the meaning of Article 12. Sales tax authority will be included within the meaning of other authorities. Then another most important judgment, wherein a principle was given. Rajasthan Electricity Board versus Mohanlal. AIR 1967 Supreme Court 1857. In this case, the Rajasthan Electricity Board, which was constituted under Electricity Supply Act 1948, the question was whether this Rajasthan Electricity Board is other authority or not. Because this Rajasthan Electricity Board, it was doing the commercial function, right? It was producing the electricity, it was selling the electricity. This is commercial function. The question is, will it be other authority or not? Now, in this case, the Supreme Court said that any authority which is created by a statute will be state, will be other authority. The only requirement is it should have been created by some statute. In simple word, all statutory authorities are state. Here the Rajasthan Electricity Board, it was created under the Electricity Supply Act, therefore it was state. And Supreme Court further said it doesn't matter whether this authority is doing commercial function or governmental or sovereign function. It is state if it is created by some statute. Next one, another case, Sukhdev Singh versus Bhagat Ram. AIR 1975 Supreme Court 1331. Now, in this case, the Supreme Court reiterated and reaffirmed the judgment given in Rajasthan Electricity Board by a majority of 4:1. And on the same principle, it said ONGC, you must be knowing, Oil and Natural Gas Corporation, LIC, Life Insurance Corporation, Industrial Finance Corporation were authorities within the meaning of Article 12 of the Constitution of India. Then another great judgment, Adi Shetty government judgment. Ramana Dayarama Shetty versus International Airport Authority. AIR 1979 Supreme Court 1628. In this case, Supreme Court gave the principle of agency or instrumentality. Supreme Court said, if there is any authority which is working for the state as agency or instrumentality, then that authority will be state. Now the question is, how to find out कि the particular authority is working for the state, it is the agent of the state or the instrument of the state. For that also, a test was given by the Supreme Court. And Supreme Court said, there are a few things which should be included over there, First one, financial resources of state is chief funding source. कि ये जो अथॉरिटी है, छोटी सी जो अथॉरिटी है, इसकी its financial resources of state shall be the chief funding of source. पैसा कहां से आना चाहिए? The money should flow from the government itself, state itself. Then, secondly, existence of deep and pervasive state control. If state will do this, it will be doing that, right? If it is following the orders of the state, that means there is some control of the state. If the control is deep and pervasive, then it is state. Then next one, monopoly status. If government has conferred monopoly status on any authority, then it is state. I'll give you the very simple example, railway, right? Railway department. So monopoly status has been given to them. So railway is state. Then comes the next one. Functional characters being governmental in nature. If this authority, whatsoever it is doing, if it is doing the functions which are governmental in nature, a justem generis principle, then it will be state obvious. And last one, if a department of government is transferred to some corporation, initially it was department of government, and any department of government is state. We already have discussed that. But if this department has been transferred to some corporation, then it is also state. Very simple example. Department of Telecommunication is BSNL. This BSNL is state. Q, earlier it was Department of Telecommunication. All these, now it is BSNL. So therefore, this BSNL is also state. Done. So therefore, if there is any authority which looks like the agent of government, yeah, or instrument of government, this agent or instrument is also state. Let's move further. Som Prakash versus Union of India, year 1981, Supreme Court 212. In this case, the Supreme Court held that under Article 12, it is not only the statutory authorities which will be included, but non-statutory authorities which are agency or instrumentalities of government will be included. Earlier the principle was that it should be a statutory authority and it should be agent or instrument. Now the principle is widening. It is saying if it is not statutory, doesn't matter, but if it is agency or instrumentality of state, still it is state. Right? Now the next judgment. Mysore Paper Mills versus Mysore Paper Mills Officers Association. Mysore Paper Mills versus Mysore Paper Mills Officers Association, 2002, Volume 2, SEC 167. Now, here we were having a government company. In this company, government was having 97% shares. The question is, will this company will be state or not? The answer is very obvious. The Supreme Court said it is state. Right. Now, the next important question which I'm going to take is whether judiciary is included within the meaning of state or not. This is a most important question. If in case some order has been issued by judiciary and we think our fundamental right has been infringed, the question is, can we still file a writ petition against the state or not, against the judiciary or not? Right? We have different views. In America, first of all, let me tell you, judiciary is included within the meaning of state, which means there, if the judiciary delivers a judgment and you think your fundamental right has been violated, you can sue the judiciary as well in the writ jurisdiction. Right? But in India, the position is altogether different. Let us discuss the position in India with the help of certain cases. The very first case is Amir Abbas versus State of Madhya Bharat. AR 1960, Supreme Court 768. Right? 768. Now, what was held in this case by the Supreme Court of India? In this case, the Supreme Court said that the violation of Article 14 by judiciary cannot be complained. It can be complained only against executives or the legislative process and can never be raised against the decision of the judiciary. Okay, done. Right. Then came another case, Amir Abbas versus State of Madhya Bharat. Same one. Now the facts of this case. In this case, let me tell you what were the facts of this case. A case was pending before the Madras High Court. When this Madras High Court was recording the evidence in this case, an oral order was given by the High Court. The order was, the statement given by the witnesses shall not be published in any newspaper, etc. Right, this was an oral order. Now, the Blitz company magazine, it filed a writ petition under Article 32 against this order. And they said, we have a fundamental right, Article 19(1)(a), freedom of press. But in this case, Supreme Court said that this Article 19(1)(a) cannot be claimed against the judicial orders. Right. Now the latest, the best judgment which will clarify all the doubts about whether judiciary is included within the meaning of state or not. The judgment is Premchand Garg versus Excise Commissioner of HP. Premchand Garg, Excise Commissioner of HP. AIR 1963, Supreme Court 997. Kindly concentrate. In this case, Supreme Court said, if the judiciary delivers a judgment, then we cannot file a writ petition against the judgment because it is a judicial function. But if the judiciary performs legislative function or executive functions, then writ can be filed against the judiciary as well. Right? So therefore, we all know what? Judiciary, it is not delivering the judgments only. It is making laws as well. For example, like in a high court rules. You go to the Supreme Court rules. If these rules made by the judiciary violate our fundamental right, we can challenge those rules. This is the legislative function which can be challenged. Executive functions. The judiciary appoints the staff. Suppose while appointing the staff, some fundamental right has been violated. And then we can obviously file a writ petition against this executive action of the judiciary. But if a judgment is delivered, then we cannot file a writ petition against the judiciary. That is all about this term state. Thank you very much.